Welcome to all of you. Glad to be with you. This is the first time I've been with you since the calendar flipped to July, and I'm hoping that all of you had meaningful July 4th holiday weekends. There is a lot to cover, and we have several presenters. And if Kathy, you'd go to the next slide, I'll walk the audience through what's ahead. Let me just make one programming note, however, at the top. Of course, most everyone should be aware by this point that the reconciliation bill passed Congress and was signed into law by President Trump on July 4th. And today we won't go through the reconciliation bill in depth just because we're still like lots of folks teasing it apart, but we do intend to have a focused opportunity or opportunities plural to bring our analysis to all of you. That may be a focused webinar that we have later in the month, or perhaps a series. We're settling on the best format to get that information to you. But all of that is in the vein of stay tuned, more to come. And when next week, you're back here on Tuesday afternoon, or at least we hope you are, expect more content concerning the reconciliation. And if there is information in between that relates to our programming, you'll hear from marketing through email, so look for that as well. After I am done walking through this agenda, you will hear from Jeffrey Weiss, who is new to the program, based in our Buffalo office, and a experienced attorney in education law, and who's been watching the Supreme Court. There are some interesting and meaningful guidance to all of you in the education sphere concerning Section 504 of the ADA. Travis Tellerico, who's out of Rochester and who's been on the program numerous times previously, is back today. He's going to be focusing on religious and medical exemptions concerning vaccinations. We've had plenty to talk about in that space over the last years, really. And as we move into a post-COVID posture, it's a good time to check back in on the issue. Kamisha Parkins will be here. Kamisha in our New York City office, again on the webinar, someone you've met before, to talk about changes in liquidated damages collection from employers by the Department of Labor in federal pay violation investigations. And then we'll close out with Kim Walcott-Agree, who's back from our Westchester office in White Plains, who'll be talking about COVID sick leave, which is coming to an end. And we just want to remind you all about why and when. So with that, let's turn to our first speaker. Let me first introduce him to all of you. Jeff focuses on school districts and special education, and he's involved in appellate practice. He has a history in government, including the New York City Law Department. After that, he's worked at several firms and has recently come to Bond and brings that background and experience with him. We're delighted, Jeff, to have you on the program for the first of what we hope will be a few presentations to come. And welcome. I'm sure the audience will learn much from your presentation. Please go ahead. The floor is yours.
Thank you, Gabe. Good afternoon, everybody. My name's Jeff Weiss, and we're here today to talk about a relatively unique event in the world of special education. We're talking about a case involving a student with a disability that winds up going all the way up to the United States Supreme Court. I work regularly with school districts on issues involving students with disabilities, and I always say the decision you make could potentially wind up in front of the Supreme Court. And sometimes I get chuckles, but now I'm proven to be right once again, as that's what happened in this case. So let's get to it. Let's get to the first slide. So the name of this case is AJT versus Osseo Area Schools. And, in short, the Supreme Court, they issued a unanimous decision, which is very unusual these days, that changes the standard for students with disabilities pursuing claims based on educational services under Section 504. There are two main federal statutes in disability law involving schools. This is the Individuals with Disabilities Education Act and Section 504 of the Rehabilitation Act 1973. And this case was brought under Section 504. Let's go into the facts. Next slide here. So the case was initiated by the parent of a teenager with epilepsy. And so that you need to have a disability to be eligible for classification under Section 504. The disability was epilepsy, and it caused the student to be unable to attend school before 12 noon. So this student needed an alternative schedule. The student's parents requested that the school provide the student with evening instruction to compensate for inability to attend a full school day. So this was an accommodation request. It was an alternative schedule with a later start time and a different end time, but the amount of services would have been the same, approximately 6.5 hours. The district denied the request. So the parents exercised their right to submit an impartial hearing request under Section 504. And their argument was that, look, this was a reasonable accommodation. The district should have accommodated the parents by offering an alternative schedule that would have lasted 6.5 hours as opposed to 4.25 hours. And the parents, they brought this hearing request, they won at hearing, and they won at in federal court. Parents were doing well. The district was ordered to provide several hundred hours of compensatory education and at-home instruction from 4:30 to 6 o'clock. So basically, the federal courts and the hearing officers said, we should have provided 6.5 hours a day. We didn't. We fell short. We only provided 4.5, 4.25. So they ordered the district to make up the missed services known as compensatory services. Next slide. So the parents, they kept going up the ladder of the courts. They requested an injunction. They requested reimbursement of costs, and most importantly, compensatory damages. So that was the theory. Now, as they're going through the court system, they're noticing that there's some discrepancy on the standard of review for a case like this. And so, what was happening is the court in their jurisdiction applied a standard of review called the bad faith standard or gross misjudgment. This is a very high standard for the recovery of damages against schools. You have to show more than simply the district didn't fulfill their obligations. They fell short. They were maybe negligent. They needed something. You needed bad faith or gross misjudgment. Now, for the lawyers out there, you know that's a very high standard. You almost need an intent to harm someone when it comes to bad faith. This is a very high standard. And so the lower court said, you know what? The district fell short, but it didn't rise to the level of bad faith. So the district prevailed on appeal, and it looked like the district was going to win the case, and the parents were not going to get to any relief. Next slide. So ultimately, it went in front of the United States Supreme Court. Now, the Supreme Court took this case because there was a split amongst the circuits across the country on this issue. And what happened is there was a lot of discussion about what should the standard of proof be for this case. Should it be the bad faith gross misjudgment standard, which the district prevailed upon, or should it be a different legal standard that's applied in other cases? It's called deliberate indifference, which is lower than bad faith. It doesn't require that sort of animus or intent to harm. It's more than negligence. It's more than falling short. Falling short of your obligations is not going to get you to a deliberate indifference standard. You need a little bit more. It's almost like for deliberate indifference, they were aware of it or should have been aware of it, but didn't follow through. But there's no intent to harm the student. There's no intent or need for animus. It's a lower standard. They're both pretty high standards, but what the court said here was, we see no reason why the deliberate indifference shouldn't be applied when that's a standard provided in other settings outside of school when Section 504 applies. These are discrimination claims. They could be brought against the government in a variety of settings. Employees could bring them. Any entity that has a connection to a governmental agency is within the jurisdiction of the government could bring a Section 504 claim. And in all those other settings, the lower deliberate indifference standard was applied. So the Supreme Court said, why would we apply a different standard, a higher standard, for students to recover in their claims against school districts? Next slide. So, they said, gee, they in their own words, it said it's inequitable to impose a higher standard of relief for students under Section 504 in compared to everything else. So the Supreme Court then said, okay, across the country, nationwide, when these claims are made, when parents of students with disabilities under Section 504 claim that their children have been subjected to discrimination and they're seeking to recover damages from the district, the legal standard is no longer bad faith. It is deliberate indifference. Now, there's a split in some in some areas. This was the standard all along. So it would have no impact on them because it just confirms that deliberate indifference is a standard. In other locations, such as where this claim arose from, where they were applying the bad faith standard, they now know going forward they have to apply the deliberate indifference standard. And in this case, the Supreme Court remanded the case to the lower court in the parent's jurisdiction to apply the deliberate indifference standard. So it'll be interesting to see in the future how the parents do and the district does under that legal standard. Next slide. So, this is going to have an impact across the country because there are many students with IEPs now, and there are many students with Section 504 plans. There are distinctions between the two. Why would a student be characterized under one versus another? It comes down to if you only need accommodations, extra time on tests, accessibility, assistive technology, you'd be under Section 504. If you need special ed services, you need related services such as speech, occupational therapy, counseling, you would fall under students under the Committee on Special Education, and you'd have an IEP, and you're under the jurisdiction of the IDEA. But both statutes, when it comes to these anti-discrimination provisions, which result in claims for damages, both statutes fall under Section 504. So this will be the legal standard going forward for students with disabilities bringing claims for damages against their public school districts. It's going to be the deliberate indifference standard. So it's no bad faith is needed to prevail. It's going to simply be, you're going to need to show a little bit more than the district not fulfilling their requirements, which would be negligence. But you do not need to rise to the level of bad faith, an intent to harm, animus against a student. That's not needed. So we'll make it easier for parents of students with disabilities to prevail in these claims. Next slide. So, the outcome here is this ruling will make it easier for students with disabilities to obtain compensatory damages against public schools when their rights are violated. These are relatively rare cases. Most cases are resolved at the hearing level, but now with the lower standard, we might see more claims going to courts for certain types of damages. And it's just a reminder to school districts, it's crucial that their staff know the rules so they could fully implement the rules that apply to students with disabilities to keep out of this type of trouble. So that's what I have today. I hope you found this information helpful.
Jeff, certainly I did, and I thank you very much for sharing it. And I'm confident that our audience, many of whom work in school districts, will follow up if they have questions. And Jeff, please come on back next time you have a case to break down or other information relevant to your practice. We're really glad you could take the time today.
Thank you, Gabe.
Of course. And let me turn next to Travis Tellerico. If we move a little bit east in the state, now to Rochester, that's where Travis sits. And Travis is with us, a regular on the webinar, and we're glad to have him back. We were discussing offline the fact that it had been a little while since we gave all of you some meaningful updates around religious and medical exemptions concerning vaccinations. And Travis raised his hand with an offer to come on and do it. So Travis, thank you so much. We're really glad to have you, and please go right ahead.
Well, thank you very much, Gabe. Pleasure to be here as always, and thank you to everybody who's tuning in. So as Gabe mentioned, we thought it would be topical to provide a general update on religious and medical accommodation requests, specifically in the vaccination context. I know we've been seeing this primarily over the last 5 years, to the extent we've been seeing issues with these types of requests, generally geared around the COVID-19 vaccine. But we thought it would be helpful now that COVID is a little bit less topical and we are seeing an uptick in vaccination exemptions for non-COVID related vaccines. Thought it would just be a topical time to go over some general best practices, principles, and the standards in relation to both a religious and medical accommodation request. So as a general overview and refresher, specifically regarding a religious accommodation, that's covered by Title VII of the Civil Rights Act of 1964, which requires employers to accommodate an employee's religious beliefs and practices unless doing so creates an undue hardship for the employer's business. Now, in a somewhat dated but still fairly recent decision from the Supreme Court in 2023, the Supreme Court changed the test as to what exactly constitutes an undue burden for an employer. So the test that the case in Groff versus DeJoy articulated is whether the requested accommodation would request insubstantial increased costs in relation to the conduct of its particular business, which takes into account all relevant factors at hand, including the particular accommodations at issue and their practical impact in light of the nature, size, and operating cost of an employer. So this standard was a pretty significant change from what the prior test was, which was more of a de minimis or a minimal cost, which was generally a lower bar for employers to clear in proving that the requested accommodation would constitute an undue hardship on an employer. Now, that's just a generalized standard. One thing that's important to know when evaluating a religious or medical accommodation request in the context of vaccination exemption is the context that the employer is in. So the test that I just articulated that the Supreme Court set forth is generally an economic test. Another significant factor that would be considered in this context, particularly if the employer is in the healthcare setting or a school, for example, is if the request for a vaccination accommodation could constitute an undue hardship in the sense that it would be a unreasonable risk to public safety and health, given that particular situation. So there's a few factors to look at there, which would be exactly what the employee does, the extent they're interacting with, with others, really kind of measuring, all right, is this actually a legitimate threat to the public health and safety? And another related point to this, and in general, it's generally considered to be an undue hardship for an employer to accommodate a request, is if that accommodation would lead to a violation of a local, state, or federal law. So that can come in specifically with requests for an exemption from a vaccine mandate. Again, this is something we were seeing a bit more during the peak of COVID times when there were, I'm sure as we all know, plethora of laws and regulations requiring employers to require vaccine mandates. But just all general points to be keeping in mind here. Now, another point in general to consider for a religious accommodation to a vaccine mandate, an employee must demonstrate that their sincerely held religious belief prohibits them from complying with the mandate. And a lot of times this is done. The examples of this evidence would be some sort of evidence that the employee regularly practices the religion asserted, complying with various principles of that religion. And a lot of times we will see some sort of an affidavit or a statement from a faith leader attesting to the beliefs of this individual or why a vaccine mandate would violate the tenets of whatever that religious belief is. Now, employers can request evidence and can work to understand the sincerity of a employee's belief, but this is generally something that you might want to be a little bit careful on how far to push this, and it is kind of on a situational basis. I'll touch on this point again later, but in the event that anytime this is a question, we always advise contacting a legal professional to go over, kind of the case by case analysis on these various situations. And just as another general point, it's always the best practice to document any sort of really anything relating to a accommodation request. So we recently saw a decision come out from the Second Circuit, the federal court here in New York's the highest court, basically, which is kind of showing what might be an increased difficulty for an employer to have determined on the merits without going fully to trial the sincerity of an employee's religious belief. So in effect, the case that we reviewed really kind of showed that the Second Circuit gave a pretty lenient standard to at least one of the plaintiffs in the case in terms of allowing her to present additional evidence to what could constitute an actually sincerely held religious belief in order to be qualified for an accommodation request. So just as a bit more explanation, the other plaintiff in that case, her case was dismissed because her accommodation request was grounded primarily in secular beliefs, not really tied to her asserted religion, and she was unable to really demonstrate or articulate actually how a vaccine would violate her religious tenets or principles. So just as in another general point, employers should always consider alternative accommodations. Again, document factors that support decisions regarding religious accommodation requests, and again, should always be on a case-by-case basis. Now, to quickly touch on medical accommodations as well, which are generally a similar principle as the analysis for evaluating a religious accommodation. We see these primarily under the ADA, which does allow employees to make request medical accommodations in relation to their disability or a disabling medical condition. Again, these are still subject on a case-by-case basis to see if the accommodation would constitute an undue hardship for the employer. Now, and again, somewhat similar to the religious accommodation request, employers are allowed to ask for information regarding the disability or the medical condition to better understand the need for the accommodation and what exactly the accommodation might be. Specifically here in the context of a exemption request to a vaccine mandate, employers may ask for an explanation from a medical provider as to why the employee's disability or medical condition would be a danger to that employee or otherwise prohibit them from receiving the exemption. In effect, an employee does have an obligation to demonstrate a need for the exemption, and an employer does have the right to understand that need. Generally speaking, though, a request for clarification should generally be reserved if the need for the accommodation is not readily apparent or known. And I know I went a little bit over my time here. This was a little good chunk of information to try to cram into the 5 minutes I was allotted for, so I apologize for that. But as a general takeaway and wrap up, if any questions arise, as I stated, this often can be a rather complex area to navigate. So we do always recommend that you reach out to your attorney or other legal professional for any specific questions in this area.
Travis, thank you so much. And you're absolutely right. It is a complex area that could really merit 5 hours, not 5 minutes. A couple questions came through the chat. If you wouldn't mind taking a peek at those, and we are, as always, grateful to have you on the program. Thank you, and we look forward to having you back. Let me turn to the next speaker who we have scheduled, keeping our travels eastward and now a bit south. We're in New York City now, where Kamisha is seated, excuse me. And Kamisha is on to discuss this Department of Labor shift concerning liquidated damages. And I want to give Kamisha the floor. Kamisha has been on the program a number of times previously. You all should know her by now, and we're grateful, Kamisha, that you could find the time again. Please go right ahead.
Thank you, Gabe. So I have some good news for employers. Effective June 27th of 2025, the Wage and Hour Division of the Department of Labor may no longer seek or collect liquidated damages in any pre-litigation investigation or resolution, including its administrative settlement investigations. Now, for those who may need a refresher, liquidated damages are an agreed upon form of compensation in a contract for harm typically done to a non-breaching party. So starting June 27th, these damages will be permitted only in matters where the Department of Labor files a lawsuit and in accordance with the law of the relevant jurisdiction or in accordance with a settlement or an award. Now, prior to this June 27th date, the amount of liquidated damages assessed to an employer deemed to have violated the Fair Labor Standards Act typically equaled the amount of unpaid minimum wages or overtime pay that was incorrectly withheld from employees, which effectively doubled the cost to employers for not following the law. Now, the wage and hour division will focus on recovering only unpaid minimum wages or overtime compensation from employers. Notably, in its announcement of this change, the Department of Labor stated that liquidated damages are only reserved for judicial proceedings and responsibility falls to the courts of law and not the agency. So that's some good news for employers to keep in mind moving forward. And that's all I have to report.
Kamisha, thank you. That's an important update for all of us. And I'm expecting that clients who are encountering these issues may need to reach out for support and understanding of the changes. And so whether it's Kamisha or other attorneys you work with at the firm, we ask all of you in the audience, please do contact us if you have questions. And now let's turn to our last speaker for the program today, and that's going to be Kim Walcott-Agree, who's with us from Westchester in our White Plains office. And Kim is also here to provide what ostensibly is some good news for employers, and it's a reminder, really, that this day that a lot of us have been talking about is basically upon us. So, Kim, please go right ahead.
Thanks, Gabe, and hi, everyone. I'm happy to be with you all again. So as Gabe stated, I'm presenting on or providing a reminder on the upcoming expiration of the COVID-19 sick leave. Next slide, please. So as many or all of you know, this leave was enacted in March 2020 in response to the COVID-19 pandemic, and it required employers or requires employers to provide employees who are subject to mandatory or precautionary quarantine or isolation due to COVID-19 with 5 or 14 days of paid COVID-19 sick leave, depending on the size of the employer. Next slide, please. The fiscal year 2025 New York State executive budget established July 31st, which is coming up in just a few weeks, as the official expiration date of the COVID-19 paid sick leave. And New York is among the last states to sunset this pandemic-specific benefit. Next slide, please. It is important to know that employers are required to continue to provide this benefit through July 31st when it officially expires. And after it expires, employees may still be able to use their sick leave provided under the standard sick leave laws for COVID-19 related absences, as long as such absences are considered a qualified absence under the law. And that is all I have for you. Thank you so much.
And Kim, thank you. It's a useful reminder for all of you who are employers just to update your policies. And if you have employees who aren't familiar with the upcoming shift, to remind them that this pandemic relating benefit is winding down in just a couple of weeks. Now, with that, let me move to close the program. I'll first note to all of you that I won't be with you next Tuesday or the Tuesday thereafter. Carrie Langan will be the host. We're doing just a little bit of schedule juggling. And then I will be the host for programs 3 and 4, as it were, that follow thereafter. I remind all of you that we're going to have some focused coverage on the Reconciliation Act and its implications for the various businesses and clients tuning into this program. Look for some focused commentary from us, as well as further direction from our marketing department in terms of what that will look like. For the moment, you can always reach me if you have questions, as well as any of the speakers who presented today, if you'd like to follow up with them concerning their presentations. We thank you very much for your loyalty to the program, and we look forward to having you back on next Tuesday. In the meanwhile, have a terrific afternoon.